Welcome back to Season 5 of the Hearsay podcast. I am Stephen Hodgson, and today, along with Sarah Dallin, Divya Chawla, and Robert Bilak, we will be continuing our conversation regarding all things human rights with Professor Jean Munn and former Chief of the Alberta Human Rights Commission, Mr. Michael Gottheil. This is the third and penultimate episode of this topic. In the spirit of reconciliation, before we begin this episode, we would first like to acknowledge that Hearsay is recorded on Treaty 7 territory. We acknowledge that Treaty 7 territory is the traditional and ancestral territory of the Blackfoot Confederacy, consisting of the Kainai, Piikani, and Siksika, as well as the Tsuut'ina Nation and Stoney Nakoda First Nation. We acknowledge that this territory is home to the Métis Nation of Alberta, Region 3, within the historical Northwest Métis homeland. We acknowledge the many First Nations, Métis, and Inuit who have lived in and cared for these lands for generations. We are grateful for the traditional knowledge keepers and elders who are still with us today, and those who have gone before us. We make this acknowledgement as an act of gratitude to those whose territory we reside on or are visiting.
What kind of changes do you think you'll see? I know you mentioned there's probably going to be more focus on systemic issues at the commission level. Do you foresee any kind of changes in how the commission does its outreach, for example? And as kind of a segue on this, perhaps Jean can speak to this as well. How would this apply now? Because obviously the commission is the Alberta Human Rights Commission. Would this have to apply to all places that aren't on reserve? How would those two things go together?
Yeah, so a couple of things. In terms of jurisdiction, I mean, this is a challenge for Indigenous people and communities. Generally, the rule is if disputes or claims of discrimination happen on reserve, then that's federal jurisdiction. If it's matters that occur off reserve, then it's provincial jurisdiction. There are some, types of cases that are more on the line, certainly like in healthcare, who's responsible. And, this is part of the case we were talking about before. So there are jurisdictional questions. One of the things that I think commissions across Canada are doing is trying to develop linkages. So, rather than telling an Indigenous individual or group that comes to the Alberta Commission, sorry, you're in the wrong place, you have to go see the federal commission. Are there ways that we can transfer the case without, sending the person to the back of the line? But in terms of your question about outreach, I think this is a really, important, that's really an important question because, and I think that in many discussions, around access to justice, there's a recognition that courts and tribunals and commissions, are not alone. They don't work in a vacuum. I mean, community groups, support organizations know that because they're working with marginalized communities that, supporting communities where people have been traditionally disadvantaged, whether it's low income, people living in poverty, people, racialized communities, LGBTQ communities, people with disabilities, these many women's shelters, immigrant settlement centers, all these organizations that have infrastructure and connections and are trusted by these communities. And I think more and more tribunals and hopefully the courts are recognizing these are resources that people already use, and we should be linking with them because these are organizations and that are trusted. Many, and we know this in Indigenous community, they don't trust the legal system, and for good reason. Generally, things don't work out well when Indigenous people interact with the legal system, and so we have an obligation to work with and reach out and coordinate so that where, for example, Indigenous individuals want to engage with the Human Rights Commission or other legal, seek other legal recourse, they're supported with trusted information and mentors and others who peers who have greater knowledge. So we have started to develop what we call navigator programs, where we link with community organizations, do training, and try to build that local support network and have that connection.
Well, I think I speak for all of us here when I say that that is something that sounds like a very exciting development, especially in lines with the calls to action and ongoing reconciliation. I really hope that the fruits you've mentioned come to fruition, because it sounds like a fantastic initiative.
You're listening to the Hearsay podcast on CGSW 90.9.
Sort of, I think, thing we've been dancing around is problems with the way the system is set up. So I'm wondering from both of you, what do you think the biggest problem or shortcoming with the commission or the system is right now?
Well, from a practitioner's point of view, from a complainant's point of view, the biggest problem is the amount of time that it takes for even the most minor of matters to be dealt with. So it is typical at the tribunal stage for a hearing to be, well, it was typical at that tribunal stage for a hearing to be held 5 or 6 years or 7 years after the complaint was made. That is no longer the case. Fortunately, it's changing a lot, but it's still a very long time between the date the complaint is made and the date that a decision comes out of a tribunal. That's still our biggest problem. I think Chief Gottheil has a lot to say about this because he's created important reforms in the commission over the past few years that have speeded up that process significantly.
Yeah, I mean, I'd say two things. One, just on in the area that Jean was mentioning, I think that is a problem. I think that commissions and tribunals across the country all have the same problem. Some delays are much worse than others, but I think that what commissions and tribunals need to think about, because there's never going to be enough money. No government service is really funded to the extent that it needs to be these days, or would like to be. I mean, I'm not going to make comments about government policy and so forth, but I do think that there are ways to be more strategic. Right. So the reality is that the commission in Alberta, and again, it's pretty much the same across Canada, will settle, between 60 and 70% of the complaints, which is a good thing. And so what we want to make sure, I think, is that the front end of the process is efficient and expeditious enough to get to those settlements quickly. Right, even if that, because of resources, it may take longer to get to a hearing. If it doesn't settle, you don't want to take 2 years to get to a mediation and then it settles. But if it doesn't settle, well, within a year later, you have a hearing. Right, it's better to have a mediation within 6 or 8 months and then take 3 years to get to a hearing, even though you don't want to wait that long. So I think there are ways to be sort of more strategic about, with limited resources, understanding how cases are resolved, looking at that, trying to adjust, adjust the processes. The other thing, just on a somewhat different note in terms of the system in Alberta, as you know, we have the Human Rights Commission, which includes what everywhere else is called the commission and the tribunal. So in every other province where there's a commission-based system, as we have in Alberta, the commission and the tribunal are separate. 2 different agencies, 2 different Crown agencies, and for obvious reasons. I mean, because the tribunal, because the commission is a party before the tribunal where the commission refers a complaint, right? So you want to ensure that the tribunal is independent. Now, I used to think, coming from Ontario, that how could you have a commission that has the sort of the complaints resolution and the prosecutorial side in the same agency under the same chief as the tribunal? That's like having the police and the crown and the judges all under one, chief justice. There's a problem with independence. What's interesting is I find that there are structures in place that address that, I think, quite appropriately. I think the bigger problem in Alberta is that the chief, in my role, because I am also the chair of the tribunal, I'm more limited in the role of a public advocate. So in all of the other provinces, your commission or the chief commissioner can truly be a public advocate for human rights, can speak out, on human rights, can take positions that may be aspirational, can take, just today's National Housing Day, the chief commissioner of the Canadian Human Rights Commission put out a statement about how housing should be seen as a human right, and what the government should do about that. Well, regardless of what I or the commission here in Alberta thinks about whether housing should be a human rights, because I am also the head of the tribunal, I'm much more limited in what I can say. And so what happens I think in Alberta, there is, we don't have as forceful a public advocate or a public voice for the aspirational side of human rights. And I think that's a problem that I've seen over the years.
Thank you. Thank you very much. So we don't want to spend too much time on this next question, but we just wanted to ask Chief Gottheil if you've experienced any human rights complaints in relation to COVID-19.
Yeah, yes. So a couple of things. So one is, as Jade mentioned, and I talked about, the commission at the front end. We part of the commission's role is we have a confidential telephone inquiry line. So we field anywhere between 8,000 and 12,000 calls a year. Just people calling up, this happened to me. I'd like some advice. Is this a human rights complaint? We get calls from employers and potential respondents, service providers. What's my responsibility? Somebody has a disability, they want time off work. What's my duty to accommodate? So we have all sorts of, absolutely, since COVID-19 and the mask requirements and now vaccine, our call volume has gone up 20 to 30%, all on COVID-19 related things. And many of those, not all, but many of those are people who are just angry. They're calling us up, you're the Human Rights Commission, I shouldn't have to wear a mask. What are you going to do about it? Right. So we've had a lot of angry calls, and that's par for the course. I mean, we see many, in many areas, the COVID-19 pandemic has caused all sorts of, has raised all sorts of questions about government policy, our responsibilities to one another, what it means, what do human rights and liberties mean in the context, generally, and in the context of a public health emergency. So I don't think it's surprising, but yes, we've seen that. Because it takes a while for complaints to move from the commission stage to the tribunal, we've only had a few cases that have come to the tribunal. I've written 3 decisions recently. There were 2 dealing with masking cases. Well, all 3 dealing with masking cases. And there are people who, in 2 of the cases, people who said they had medical exemptions The third case, the individual said he had a medical and a religious exemption. And, essentially, not surprisingly, well, all three cases were dismissed on the basis that it is a public health emergency, and the stores that were the respondents had provided alternatives in terms of curbside pickup or home shopping, online shopping, and that sort of thing. I think some of the more difficult or challenging questions will be, and we haven't seen them yet, what about employers who implement vaccine mandates, saying you need to be vaccinated to come to work, and if you can't because you have an exemption, or you won't because you don't want to, you have to provide proof of that you've had a test, and who's going to pay for that, right? And I think we've yet to see some decisions on the vaccine side of it. And the other thing I think what we're when it comes to vaccines as opposed to masks, I think it is a more what we're seeing, it is a more difficult question. Many of the mask cases, there's people, it's really about, you're not going to tell me what to do. In the vaccine cases, many of them, there are people who, say this is invasive, and this invades my body. These are privacy issues, and what's I think quite interesting is, and this almost is full circle to our discussion, what we started with, which is the difference between the Charter and human rights. There may well be a Charter claim of security of the person. You can't force me to, stick a needle in my arm and inject me with a vaccine. Full disclosure, I'm vaccinated, I'm not anti-vaxxer, but I can see where there could be an argument. I have no idea what, in the end of the day, whether that would amount to a violation of security of the person. Certainly, there's going to be a Section 1 argument. We know that. But, I can see where, somebody could say there's a claim for security of the person in terms of vaccines. Whereas I just don't see, under the Human Rights Act, there is nothing in terms of security of the person, right? I mean, you can say I'm being discriminated because of a disability, but if it's somebody who simply says, I don't have a disability, I'm not going to get an allergic reaction because of a vaccine, I just don't want to have to be vaccinated, and it's my body. I think we've yet to fully to see cases that fully explore that question.
I would like to see somebody argue that religion in the human rights legislation has to include conscience. Religion is a fairly old-fashioned concept that involves deities and rules. But what if your value system is perhaps even more virulent, but has nothing to do with the deity? So I think that some good, ingenious arguments could be made. Interestingly, Chief Gottheil, I don't know if we told you, but the human rights assignment, which involves drafting a complaint and doing a memorandum in the nature of a legal opinion to a client, has to do with a complainant who doesn't want to be vaccinated to go to work for the health authority doing IT. And so it'll be interesting to see what arguments are coming up.
This is a follow-up to both of your answers in this discussion. Is there a mechanism because I imagine there will be eventually a line of complaints related to this. Would the Human Rights Commission ever just say, okay, you're better to get a remedy from a charter context? Would they ever turn a claim down on that basis, or would they try and adjudicate it in some regard, through the tribunal, offer, I know they can be guided by charter principles. How would that process look?
Well, it's been done before. So in the Vreend case, the Alberta Human Rights Commission refused to hear this fellow's complaint that he'd been fired because he was gay. They were just refused to hear it. So that would be perhaps something that might happen. The director would say, there's no claim here based on the parameters of the legislation. Then you'd have that person request a review, and a member on what's called a Section 26 decision say, no, I think religion does include conscience. And then you could have a respondent go to appeals on that, or judicial review. I don't know what would happen. I think it's most likely a director at this point is going to say, depending on how it's framed, that doesn't belong within the purview of the Alberta Human Rights Commission.
You're listening to the Hearsay Podcast on CGSW 90.9.
I think there's a couple of different situations, right? So, we have had people call, and I don't deal with the complaints at the front end. So I imagine we've had some complaints that have been filed, against the Alberta government for implementing the mask mandate, or, vaccine policies in terms of, mandatory vaccine to enter, retail establishments or restaurants or that sort of thing. And so, in those sorts of situations, we would just say, look, you're not alleging any violation of the act. And there's been a couple of cases out of British Columbia that are similar, right? That people have filed human rights complaints against the public health, Bonnie Hendry, who's the chief public health officer of British Columbia, or against the premier for bringing in vaccine or mask mandates. And the Human Rights Tribunal says, look, we just don't have jurisdiction. And those are situations in which, potentially there's a charter claim. I'm not saying it would be successful, I don't know. But potentially there's a charter claim based on, maybe freedom of religion. If the person says, my religious beliefs are such that I can't take a vaccine or can't wear a mask, that's fine. But of course, human rights has to be grounded in a particular area, right? I shouldn't say grounded because that mixes up with ground. It's that I was refused employment, or I was terminated from my employment, or I wasn't allowed into a restaurant, or I wasn't allowed into a store without a mask. And so, or I wasn't provided a service in a hospital. But if it's just somebody who says, I think government policy violates my rights, well, that might be a charter claim, but it's not a human rights complaint, right? Unless they've been denied service or employment or housing. So I think in those situations, we would just say, look, we don't have jurisdiction. Now, in other kinds of cases, it may, there may be an overlap. And I'm thinking of a case about a year ago that we had in which a firefighter alleged that he was being forced to retire and take pension at the age of 55, I believe, or 60, I can't remember, 60 maybe. All right, and part of the collective agreement and the pension plan provided that you get full pension at the age of 60. He didn't want to retire. He said, it's discrimination based on age. And of course, there was discrimination based on age on the face of it. However, the Human Rights Act has a provision that says where a distinction is made on the basis of age, there are a couple of other grounds, but at least age, in respect of a pension or health and benefit plan, that there's no violation of the act. So it makes an exception for age violations in relation to pension or health and benefit plans, right? So, and most human rights acts across the country have that. I mean, it allows for not mandatory, but it allows for different levels of health benefits when you reach a certain age, or differential premiums, based on certain factors, those sorts of things. Now, so when this complaint was filed, that complaint, it was dismissed because there was an exception in the Human Rights Act that said a distinction based on age in respect of a pension plan is deemed not to be an act of discrimination. Now, there's no question that that individual could have said that provision of the Human Rights Act violates my charter rights. Now, again, whether he would have been successful, whether it would have been saved on Section 1, I don't know. In some provinces, the Human Rights Tribunal is a court of competent jurisdiction and can decide charter questions. So in a case, but not in Alberta. So the case of Tranche-Montagne, and there's another case which said that a tribunal that has the jurisdiction to decide questions of fact and law is a competent is a court of competent jurisdiction to decide charter questions, unless the legislature specifically removes that jurisdiction. And in Alberta, the Human Rights Act removes the tribunal's jurisdiction from deciding charter questions. So in a case like that, if that individual, that firefighter, said, okay, fine, yes, there's an exception, but I want to challenge that provision of the Human Rights Act, he would either have to go to court and challenge that, or he would ask the tribunal to state a case to the Court of Queen's Bench to decide that charter question in the context of his human rights complaint. So there's an example of where the two, in addition to what Jane talked about, where the two could overlap.
Was the case you were thinking of Dore?
No, so the case, no, it was Conway, R versus Conway. So that was no, Dore is a case dealing with charter values, but no, R versus Conway is a case in which a review board or a tribunal that makes decisions about for individuals who are found not criminally responsible because of a mental illness, whether they could decide charter questions. And the Supreme Court said they could.
The Hearsay podcast would like to formally thank Professor Jean Munn of the University of Calgary and former Chief of the Alberta Human Rights Commission, Mr. Michael Gottheil, for taking the time to interview with us today and providing our listeners with some invaluable insight into the processes and procedures surrounding the Human Rights Tribunal and the Human Rights Commission. The Hearsay podcast is proud to present you with legal information, but it is important to remember that this is information and does not constitute legal advice. We are law students, not lawyers, and the podcast is purely for informational purposes. If you do require legal advice, please consult a lawyer, as there is no substitute for a professional. Thank you for listening to the Hearsay podcast. The Hearsay podcast is a joint project between CJSW and Pro Bono Students Canada at the University of Calgary chapter. We would like to take this opportunity to thank CJSW for all of their support. If you would like to hear more podcasts like this, the Hearsay podcast can be found on Apple Music, Spotify, Google Podcasts, or wherever you get your podcasts. Thank you for listening, and we'll catch you next time.